Hello and welcome to Student Affairs Live. I'm your host, Tony Doody, and I'm pleased to be joining you from my professional home at Rutgers University. We broadcast on the Higher Ed Live network, and you can tune into Student Affairs Live along with my brilliant friend and co-host, Heather Shea Gasser, Wednesdays at 1 o'clock Eastern Time. If you're unfamiliar with past episodes, I highly recommend you check out and favorite the archive link that we're tweeting out now. We're proud to cover important topics with some of the very best practitioners, scholars, and experts in the field, as evidenced by our fabulous guest here today. In a moment, I'll introduce you to Dr. Lee, but we can't do that without first giving a shout out to the sponsors that make Student Affairs Live possible. Higher Ed Live is produced by M. Stoner, a marketing communication firm that works with education institutions on branding, strategy, web design, and more. Now, due to its popularity last week, M. Stoner is offering a reprise of their free webinar on successful social campaigns in higher education, featuring Higher Ed Live's own Ashley Budd. We're tweeting out that link now, and you can learn more and register for this free webinar. Now, Student Affairs Live is also sponsored by ACPA, College Student Educators International. ACPA's strategic partnership with Higher Ed Live calls attention to the pairing of innovative professional development delivery with the strength of a renowned professional association. ACPA publishes the Journal of College Student Development and About Campus, and has recently launched a new content delivery platform, ACPA Video on Demand. Check it out today at videos.myacpa.org. And if you haven't registered for APA's National Conference, click on the link we're tweeting out now to learn why you should join us in Montreal. And if you're heading that way and would like to see connect with me, I'll be presenting at a pre-conference institute on technology with some well-known icons in digital tech, including Laura Pasquini, Ed Cabellon, Paul Gordon-Brown, and Josie Alquist. I'll also be co-hosting live stage micro-debates on contested issues in student affairs with quite an all-star cast of leaders and scholars. So I will also, before we get started, want to thank Kate Zulo and Carrie Locke, who are in the studio here with me right now. And they're tag teaming the monitoring of today's back channel and forwarding me your best content and questions from the Twitterverse. I want to remind today's audience, that these episodes are really designed to be interactive. Your engagement throughout with questions and comments on Twitter really improves the quality of the live dialogue. So finally, I'm very honored to have join me today Dr. Barbara Lee. You can read her full biography on the episode page, and I want to get out of the way and stop talking, and because we have so much good information, fun information to cover here today, although some people might not classify that as fun, right? Dr. Lee, Barbara, would you please describe your current role and what first led you to the field of law?
Sure. Hi, Tony, and hi to everybody who's listening and watching. My current job is Senior Vice President for Academic Affairs at Rutgers University. I've been in that role since July, but I've been at Rutgers for 33 and a half years on the faculty. So it's a new and sort of unfamiliar job, but certainly the university is one that I love and have served for a long, long time. So at Rutgers, we are big and kind of messy in some ways. We have 4 chancellors, one in Newark, one in Camden, one here in New Brunswick, and one for our medical and health professions units. And my job really is to deal with academic affairs that go throughout the entire university. So some of the people who report to me, for example, are the institutional research folks. I chair the Promotion Review Committee, which is a committee of faculty who make recommendations to the president about promotion and tenure decisions. The Global and International Affairs Vice President reports to me. The Director of Veterans Services reports to me. The Rutgers Press reports to me. Our Division of Continuing Studies is in my bailiwick. Diversity and inclusion, university-wide, is also part of what I do. The university library system is part of my portfolio, and there are a few others, but that's probably enough.
Just a few things. Just a few things.
Yeah, just a few.
So what first led you into the field of law?
Well, I got a PhD in higher education administration at Ohio State, And in those days, faculty at some colleges and universities were just beginning to form unions. And I didn't know very much about labor unions. I thought it was really interesting that faculty would feel the need to be represented. I sort of looked at colleges and universities as collegial places, not places where there were differences in points of view. I've since learned that obviously was a pretty naive belief. But in any event, I thought that academic labor relations was just fascinating, and I did my doctoral dissertation on how decisions were made at colleges and universities where the faculty were unionized. And I realized that once I had gotten into it, a law degree would be really helpful. So when I finished my PhD, I moved to Washington, D.C. and enrolled at Georgetown University Law School at night. Nobody was paying my tuition, so I worked during the day. The first 2 years I was at the U.S. Department of Education in their higher ed policy unit. And the second 2 years of law school, I was at the Carnegie Foundation for the Advancement of Teaching. So I basically worked my way through law school and finished in 4 years, which is the part-time option for law school, and just fell in love with higher education law. I never really planned to teach law, but once I got bitten by the law bug, I just couldn't help myself.
Well, you definitely got bit by the bug. I mean, you are a co-author of the book, The Law of Higher Education, now in its 5th edition. And that first edition, published back in 1978, was only 500 pages long. And there's the student edition, and then the full version is 2,128 pages. Is the increase in content an indication of the complexity of issues? And if yes, what are some of those driving factors behind that change?
Well, that's a really good question. I could talk for a whole hour on that, but I promise I won't. There are a lot of reasons, Tony. One important reason is there's just a whole lot more litigation now than there was in 1978. Very few students sued colleges and universities in those years. Can't say that anymore. Faculty, if they didn't get tenure or promotion or even hired, they tended not to sue. That is not the case anymore. We have a lot more federal regulation than we used to. A number of laws have been passed, and regulations as well, that were not in effect in the 1970s. The whole area of discrimination law has boomed. There was no such thing as sexual harassment. I mean, there was sexual harassment. There just wasn't any legal recognition of remedies for sexual harassment in the 1970s. That's just one example. Title IX, which was enacted in the 70s, was mainly applied to athletics in those years. Now when we talk about Title IX, we're primarily talking about sexual assault. And obviously it still applies to athletics, but that seems to have less of a focus than it did in the 70s, 80s, and 90s. So the whole area of research is heavily regulated and much more so than it used to be. The whole area of student affairs has gotten much more complex in terms of legal issues. And, it's interesting. Colleges and universities, particularly public ones, because they're subject to the Constitution and other laws that regulate public entities, really are more heavily regulated than any business, no matter what the industry is. We have to follow all the laws that businesses follow. The publics have to obviously obey the U.S. Constitution and other laws that regulate public entities. We have space law, we have maritime law, we have intellectual property law, you name it. Any area of the law affects a college or university in ways that other businesses or other entities just don't have to think about.
Well, so do you suspect that in 20 years your book will double again in size?
I wouldn't be surprised, and in fact, we just signed a contract for the 6th edition, which is a little terrifying. That's due out in 2018, which means we already have to start it, of course. But we're talking about a fully online product because, for one thing, it's really heavy to carry around right now. I can't imagine doubling the weight. I mean, everybody will be, their right arm will be longer than their left as they try to carry it around. But it'll also allow us to update it more easily. The law changes constantly, not just once every 3 or 4 or 5 years. So fortunately, technology is going to enable us to make it as long as we want to make it, and without the constraints imposed by a publisher who says, well, we really need to be able to fit this book inside a cover. We can't have it so big, and that's why it's 2 volumes. We can't have it so big that it can't physically be located inside a cover. So yeah, I wouldn't be at all surprised if it doubles in size.
Wow, that's exciting. So for the higher ed professional or student affairs practitioner that's watching, how do we keep up with this expanding knowledge base? Do you have any suggestions, strategies on what we could do, what we could read?
Oh, I think there are a lot of resources. I think the Chronicle of Higher Education and Inside Higher Ed both are fabulous sources of information on legal issues, because they not only follow what's going on, but they analyze it, and they include comments from experts. Sometimes experts disagree, particularly in law, but they really do a nice in-depth job, I think, both of those publications. Also, the student affairs organizations, NASPA and the others, have updates that are very, very helpful, and student affairs folks really need to follow them. This whole area is changing so quickly. I would bet you that 5 years ago, no student affairs professional would have said that somebody can keep an animal in their room, for example, in their residence hall room. And now it's not at all unusual to have that happen. And it may be eventually that we won't even require students to prove that they have some kind of a disability in order to be able to keep an animal in their room, simply because it'll just be easier not to have to. Now, that's a prediction. I'm not saying that that's absolutely going to happen, but it'll just be easier for the residence life people not to have to go through the process if you've got 50% or 75% of your students, insisting that they keep an animal in the room. And that's just one example of the changes that have happened in the last 4 or 5 years.
Wow, and that, of course, has implications for the design of residence halls and other university facilities, right, to accommodate all these animals.
That's exactly right.
So we often get lots of grad students who read this as part of their syllabus for their classes, and we certainly have lots of second-year graduate students that are beginning to look for jobs this season, and they'll have lots of choices about the types of institutions that they can apply to. So when it comes to legal issues, what are some of the differences we should be cognizant of between private, public, and religiously affiliated institutions?
Okay, that's a terrific question. Let's start with the religiously affiliated institutions, because I think those differences are the most obvious. If it truly is a college or university that is not only sponsored by a religious organization, but the religious tenets are interwoven into the daily life of the college, if the faculty are expected to, if not be members of that religion, at least live by the tenets of that religion, if the students are expected to behave in ways that the religion requires, then the legal issues are probably less broad, because those are the clear expectations, well, for 2 reasons. One is that it's the clear expectations of the college, and they make that clear in their recruitment materials and their student code of conduct and their course catalogs and their faculty requirements. But secondly, the courts, because they are the government, the First Amendment's establishment and free exercise clauses say that the government can't get involved in deciding what a religion should or shouldn't do, or should or shouldn't be, or should not tell its employees or its students that they may not do, because the courts are a representative of the government. So, for example, colleges that might dismiss a faculty member for acting in ways that are against that religious institution's rules can't be sued for religious discrimination. There was a case at the U.S. Supreme Court a couple of years ago where a faculty member attempted at a religious college. I think it was actually a K-12 school, but it doesn't make any difference. The rules are the same. was terminated, and she alleged that it was because of a disability. The court said, we can't address that issue because you had what they called pastoral or ministerial responsibilities at the school. She led prayers, she was teaching religious classes, she had to be certified by the church as a religious teacher. And so the court said, well, if that's the case, then your employment agreement is between you and the school, and the government cannot wade into the middle of that dispute. So that's an example. It's a real hands-off attitude. So religious colleges are much freer to do, within reason, of course, what they wish with their students and their faculty members, because there's a much more limited ability to sue them in the courts. All right. The next level is private, independent colleges and universities. They clearly are subject to all state and federal laws that regulate other private businesses, but they're not subject to the United States Constitution. So they're not subject to the free speech requirements, for example, of the U.S. Constitution, except in California, where there's a state law that says that students in California private schools have the same free speech rights as those in public schools. But that's California, and California is often a little different from the rest of the country in terms of its legal requirements, and other ways too, but we'll stick to the law this afternoon. So the main issue at a private college or university would be, well, what do our handbooks say? Have we promised free speech to our students and faculty, even if we're a private college? And many of them do. So then these folks do have free speech rights, but they're not constitutional rights, they're contractual rights. And so there's a different legal approach to that sort of thing. And then the kind of institutions with the greatest protections for faculty and students are the public institutions. So from a student affairs perspective, which is obviously what we're talking about today, it's much more difficult to regulate, for example, student use of social media, something you know a little bit about, Tony, at a public college or university because of the First Amendment free speech guarantees for our students. So I kind of laughingly say to my students, and I know you've heard me say this in the class you took with me, that if you have a choice, work for a private college because there are just not as many legal issues. It doesn't mean that it's easier. It doesn't mean that the problems are any easier to solve. It's just that there are only like 10,000 ways you can get sued instead of 25,000 ways you can get sued if you're in a private school.
There you go, folks.
You heard it here.
That's right. So I want to jump to a timely issue right now. There's an important affirmative action case, Fisher versus University of Texas at Austin, that's currently before the Supreme Court. Can you briefly describe the history of this case and why it's so important to the future of higher ed?
Sure. Actually, this is a case that has been going for a while. And if you don't mind, I just want to mention that there was an earlier case called the Grutter case at the University of Michigan Law School, and I believe it was 2003, where the University of Michigan Law School's affirmative action admissions policy was actually upheld by the U.S. Supreme Court because they used an individualized review of every application, and race or national origin or ethnicity was not a automatic admit or deny criterion. So after that case was decided, many schools started much more explicit use of race or national origin in their admissions processes because the Supreme Court had well, in a 5-4 decision, had said it was okay. So the University of Texas, in the meantime, was under a state law that is called the Top 10% Law, where the public universities in Texas are required to admit the top graduates in the top 10% of their high school graduating class. And so, of course, the University of Texas at Austin, which is the school involved in the current case, is a very desirable, very prestigious public university in Texas, and a lot of people want to go there. So they admitted students from the top 10% of their class, but they still were not comfortable with the racial and ethnic composition of their freshman class each year. They felt that they wanted to increase the diversity of their class. So they did use race and ethnicity as one of many criteria for making admissions decisions. So Abigail Fisher was a Caucasian young lady who was not in the top 10% of her graduated class in high school, applied to the university and was denied admission. And there is a fair amount of evidence to suggest that even if the university hadn't used race or ethnicity to make admissions decisions, that she wouldn't have been admitted anyway. But she challenged the affirmative action process in admissions at the University of Texas. It went from the trial court, which ruled in favor of the university without a trial, to the appellate court, a federal appellate court, which also ruled in favor of the university without a trial. And then she appealed to the U.S. Supreme Court, which didn't really make a decision. The Supreme Court said, well, we think that the trial court and the appellate court used the wrong standard. We're going to send it back to the lower courts to make sure that the strict scrutiny standard, which is what the legal standard is for equal protection claims. This was a alleged denial of equal protection under the 14th Amendment of the U.S. Constitution. We're going to insist that you make sure that the means that you use to make admissions decisions are, quote, narrowly tailored to make sure that there's the least amount of discrimination. So it went back down to the trial court. The trial court again ruled without a trial that the university did not violate the 14th Amendment. The appellate court agreed, and now it's back before the U.S. Supreme Court. A lot of us think that there's enough of a majority on the U.S. Supreme Court that probably the case will go against the university, but it's hard to say. The oral arguments were held in early December. You can't always tell from what the justices say from the bench, the questions that they ask, how they're going to actually come down when they make the decision. So I think a number of people are very concerned about what may happen, but we're not going to know until spring at the earliest, probably the end of June at the latest.
And if I recall correctly, you were part of one of the amicus briefs.
I was cited. Yeah.
Cited.
My book was cited in one of the amicus briefs, and boy, that doesn't happen to very many people.
Yeah,
once in a lifetime, so that was exciting.
Congratulations.
Thank you. Thank you.
So I know that we could do a whole show on affirmative action, and actually there was an op-ed in the New York Times yesterday called Rethinking College Admissions. I'll ask folks to tweet it out in just a moment. There was a report that just came out called Turning the Tide that really suggested that we downplay AP courses and SAT scores and come up with alternative methods. So perhaps that will be a whole other show on affirmative action. But I do have a question. So would that ruling, if it goes that way, would it also apply to private institutions?
Yes, because Title VI of the Education Amendments is, well, it would only apply to any private school that gets federal student aid, which is all but about 3 private colleges and universities in the United States. So Title VI and the Equal Protection Clause are evaluated the same way by a court.
Okay. I'm going to move on to a hot topic in the news. The debate about gun restrictions and the constitutional right to bear arms has certainly been a hot topic, particularly at universities. And this fall at Liberty University, which is, for those of you who don't know, is a nonprofit Christian university in Virginia, the school president, Jerry Falwell Jr., lifted a ban on guns in university dormitories, and I quote dormitories, I don't want to get in trouble for using that word, in student affairs, and urged his students to arm themselves and to learn to shoot. And then this past year, a new state law in Texas will allow concealed guns to be carried into buildings on public university campuses. And then Texas is just one of 9 states that will have or will soon have provisions that allow campus carry. Now, I think the majority of colleagues watching this show, certainly not everyone, but the majority would agree that allowing guns on campus, and in particular residence halls, could have disastrous effects. And we know that brain science and research have shown that traditional age students, ages 18 to 24, have an increased propensity for risk-taking, excessive drinking, substance abuse, due to their still forming prefrontal cortex. Additionally, multiple reports are showing that an alarming number of today's college students are suffering from mental illness. So one might argue that guns, risky behavior, alcohol, and this increase in psychological issues represents a really dangerous mix and a foreseeable danger that could expose the university to costly negligence suits. So that long-winded setup, my question to you is, how do you think this might play out in the courts?
Well, I'm very troubled by this also. Not only I worry very much about students harming themselves or other students. I also would recognize that students don't always like what their professors say or do to them, and I don't want to have to wear a bulletproof vest when I'm teaching in my classroom. But in any event, back to the legal issues. I don't know. I have a guess as to what might happen. You have dueling legal theories here. Clearly, a grieving parent probably would try to hold, or could try to hold, a college or university liable under a negligence theory. They certainly are doing that with student suicides right now. They're saying that colleges are not doing enough to prevent student suicides. And I can see the argument that a parent's attorney might make that even though colleges have to let students keep guns in their residence halls, perhaps, on their persons, that they haven't done enough training, that they haven't done enough preventive work. On the other hand, you've got a state law that says that the college, particularly public schools, must allow these guns to be on campus. And that seems to be like a very strong defense to a lawsuit. So I think in a very odd kind of way, and I'm really going out on a limb here because I haven't done a lot of looking at cases that may have come along, that colleges in states where concealed carry is an absolute right and the college can't ban guns on campus or in residence halls are in a safer place defense-wise than a college in a state where concealed carry isn't required, where there's a shooting on campus. You understand what I'm saying?
Yeah.
That the Texas and the Utah and the other states where concealed carry is required gives colleges a legal defense that those colleges and states where the gun laws have not been enacted that way would not have.
So yesterday, an interesting twist on this, the Chronicle had an article about the Georgia, a legislator in Georgia is suggesting that they, instead of allowing guns onto campus, that they allow tasers or electronic shock devices onto campus as an alternative, as a creative alternative. Would that fall under the Second Amendment, right?
Well, that's a good question. The Second Amendment talks about bearing arms, and I guess arms, I don't know whether that's firearms or whether it's any kind of weapon. A taser can kill someone if it's used incorrectly. Certainly, I guess if I had my choice between a gun or a taser, I'd take a taser to be hit with, but I think they're still dangerous. Whether the Second Amendment applies to other sorts of weapons like knives, I don't know. I think I would not be comforted by knowing that a child of mine was on a campus where there were no guns, but there were a lot of tasers.
Fair enough. So for those who have an interest in this topic, I just want to point out, and again, we'll tweet out the link to this. Next week, my co-host will be doing a whole show on stopping gun violence called College in the Crosshairs, and it'll have the executive directors from ACPA and NASPA talking with one of the authors of the book, which we'll also tweet out. So if you have an interest in that topic, I suggest you tune in. Now, this next question is a broad question, but I'll see what you think, and I'm sure you've touched on some of these issues already. But what would you consider to be some of the next big legal issues that you think might change our field dramatically over the next decade?
Oh boy, that's a tough one. I think the whole area of privacy is incredibly important. I mean, we do have FERPA, and I guess Student Affairs 101 is always about FERPA, right? Because we worry about what is an education record and what kind of protections students have under FERPA. But you know, we're very concerned about the whole student. When I was in college 100 years ago, it was really academics that people worried about, and I don't remember any kind of student affairs interaction at all when I was in college, and that's changed a lot. So we're thinking about students who are at risk. We're thinking about students who may have adjustment problems. We're thinking about students who may be struggling with their sexuality. We're worried about students who may have mental illness issues. There are many more dimensions to students that we as student affairs people are thinking about and intervening in for good, for positive reasons. But that also has implications for privacy. And it's going to be very interesting to see because we don't have very good legal tools to deal with privacy. I think FERPA is a pretty blunt instrument, really. It only applies to things that are written down, for example, education records that are in writing but are maintained by the institution. So telephone conversations may not be covered by FERPA. Certainly, me talking to you informally is not, unless you write down what I say, is not covered by FERPA. So there are a number of privacy issues, I think, that are troubling. And the whole area of social media and what happens on social media and the friction between anything goes on social media because that's supposed to be what it's for versus the targets of social media conversations who feel that their privacy has been invaded. I just think that's a huge area that the legal system just doesn't know how to cope with at all. Not at all. That's just one example.
Yeah, it will be interesting to see what the tensions are, and there certainly has been lots of tension between privacy, particularly with all these terrorist threats, right, and trying to protect privacy versus protecting national safety issues. And we can talk a little bit about social media in just a moment. We got a question that came through Twitter about activism, and certainly student affairs professionals, particularly senior student affairs professionals, are likely to deal with student activism through protests, sit-ins, and building takeovers. Can you talk to some of the legal principles that apply to these situations and maybe offer some counsel on how we could prepare and respond?
That's probably the most difficult part of the course I teach, is the whole area of protest and free speech and how institutions should be responding. And it's almost, you know, you're darned if you do and you're darned if you don't in many ways. Certainly the whole area of pre-approval of protest is very dicey from a legal standpoint because often institutional representatives, for very understandable reasons, are more concerned about the content of what the protest is about than they are about the actual protest itself, because it may be something that they don't approve of, that may be something that they know will upset other portions of the community. It may be something that involves an outside speaker who is brought in by a few students who then enrage another group of students. So the whole area is really tough. What it's hard to remember is that the most important thing to regulate is behavior, not speech. And so you have to be prepared for protest, and there's certainly been plenty of it in the past several months. You look at Missouri, you look at Princeton, you look at Yale. But if the protests are peaceful and they're not threatening individuals or destroying property, and there's not a public safety issue, then they really, in most respects, have a right to do it, particularly if they're engaging in this activity in a part of campus that's been set aside for this sort of thing. And public institutions in particular have something called time, place, and manner policies, where you can't protest at 3 o'clock in the morning, even though many students are still awake at 3 o'clock in the morning. That's not a time of day when we prefer to have protests happen. Place, you don't want protests going on in the quiet room of the library, but maybe in the square or a green in front of some buildings is perfectly fine. And the manner, M-A-N-N-E-R, how are you going to do it? Are you going to use a public address system? How many, are you going to engage in behavior that could be viewed as menacing? That sort of thing. So the whole area of student protest, I think, is very, very difficult in legal terms. There's a term called the heckler's veto, when you have someone giving a talk, and well, you see it you see it in some of Governor Christie's town hall meetings, where he makes a statement and someone starts yelling at him because they disagree with him, and that's called a heckler's veto, and that's not protected necessarily by the First Amendment. We all have a right to our own opinions, we just can't all say them at the same time. So I'm not sure whether I'm answering your question very well, but
it's complicated.
It's complicated. It's very complicated, particularly at public institutions. Yeah.
Great. So I'm going to move back to this issue of social media, and because it's so relatively new for law, we have lots of student affairs departments, deans of students, health services, public safety, admissions, who monitor social media for a whole range of well-intended reasons. And there's a balancing act between protecting student interests like privacy and free speech versus institutional interests such as ensuring a safe and positive educational environment. Is there greater liability associated with monitoring? So if we know about an issue, do we have a corresponding duty to act?
I think monitoring social media is problematic. If the whole area of negligence law says that if something bad happens and it was foreseeable, then anyone who was in a position to prevent it from happening or to protect the individual has a duty to do that. So if you are monitoring social media, for example, I think my son's baseball coach at his university monitored the baseball players' Facebook pages and other social media to make sure that they were following team rules about alcohol use and that sort of thing. The problem is that if you find out something, you need to act on it. On the other hand, and I'm going to do something lawyers do all the time. They're going to say on the one hand and on the other hand and not give you a straight answer at all. So I apologize in advance for doing that. But on the other hand, if you know that a student is at risk and you don't monitor social media, then you may also have a negligence issue because you had information that the student was at risk, and yet you did not choose to make sure that the student was not planning some kind of violent behavior either toward him or herself or others. So it's another one of these situations where you pick your lawsuit, and unfortunately in higher education there's a lot of pick your lawsuit situations where you just have to decide whether you'd rather be guilty of negligence or guilty of wrongful death or something short of wrongful death, endangering either that particular individual or people with whom he or she come in contact. What really frightens me a lot these days is that I don't know if the prevalence of mental illness on campus has increased. Certainly the reports of mental illness on campus have increased. And I don't know whether it's because more individuals with mental illness are accommodated in K-12 education and therefore can function in a higher education setting, whereas 30 or 40 years ago they couldn't, so they would not have come to campus, or whether there is an increase. And that's not my area of expertise, so there's no point in my trying to speculate about it. But it certainly puts a lot more pressure on not just the student affairs side of the house, but faculty as well. I'm involved in a case where a graduate student committed suicide. He suffered from major depressive disorder, and the parents are suing the institution because the faculty were not trained to recognize major depressive disorder and did not intercede on his behalf. And my concern is that I don't think that that's the role of the faculty, but maybe someday it will be. If this trend toward increasingly troubled students continues, we're not going to be able to compartmentalize it just to the time when they're not in class, particularly for graduate students who are working, you know, in a lab or other places side by a faculty member where they're not just in class for 3 hours a week, but they're working very closely with their mentor most of the day, every day. That's a very different kind of relationship than lecturing in a 250 student lecture hall. So that worries me. I think that that's something that both the legal folks and the student affairs people need to think about.
Wow, the expectations for knowing how to deal with students on all this huge range of issues is intimidating. I'm going to go back to a question that I skipped earlier. If you had an hour with new faculty and professional staff during a new employee orientation session to talk to them about legal issues, give them a foundation, what are some of the things you would be sure to cover?
Okay, well, this is actually something I'm going to be talking about at a conference for college attorneys in June, so I've had a little bit of time to think about it, fortunately. I think that faculty and professional staff need to understand that they're not just there to do what their job description says, and so there's some resistance to that, but they are representatives of the college or university. They are the student-facing people. The lawyers aren't. You know, hopefully the students will never see any of the lawyers. Hopefully the faculty will never see any of the lawyers. But the people who are student-facing have compliance obligations. They have obligations under Title IX. They have obligations for ensuring that FERPA is enforced properly. They have obligations to make sure students understand that they have academic freedom and free speech rights. So I think what I would start out by saying is that I'm going to spend an hour with you talking about some of the areas that you have responsibilities that you need to take seriously, because otherwise you're going to get the institution into legal trouble, and maybe yourself as well. Title IX is certainly one. I think where everybody is 24/7 thinking about Title IX, particularly since the Office for Civil Rights has stated pretty clearly that most employees at a college or university are what are called responsible employees and have to pass along excuse me, any reports of sexual assault or sex discrimination or harassment. I don't think most faculty see themselves in that role, and probably a lot of professional staff members don't either. And yet they do have that role, and they need to understand that role, and not only understand that they have the role, but what to do about it, who to tell, who to pass it along to, how to help the student. There are over 200 colleges and universities right now under investigation by the Office for Civil Rights. I'm not suggesting that they've all violated the law. My guess is that most of them haven't. But it may just be that some folks just didn't understand their obligations. So Title IX is one example. Another thing that's going on that I think is very troubling around the country is the conflicts between students and faculty. In class, a student will say something that a professor takes exception to, or vice versa. Because of the prevalence of social media, the dispute gets put on social media. Politicians pick it up. Political organizations of any stripe, whether conservative or liberal, pick up the story, and then there's a deluge of criticism coming on the institution for either its students who are saying things that these folks disapprove of, or even worse, the faculty who are saying things that these folks disapprove of, and I want this person fired, and on and on and on. And social media isn't entirely to blame, but misunderstanding about the intersection between the freedom to speak professionally, respectfully, appropriately in the classroom, and others' rights to disagree with that really needs to be clarified.
So that brings me to a contentious social media channel. Yik Yak is one of those anonymous social media applications that's led to online harassment, intimidation, slander, slurs, threatening behavior. Is this kind of anonymous expression facilitated through sites like Yik Yak protected by the First Amendment? And should or can student conduct codes hold students accountable for social media that's not controlled by the university and often takes place off the university grounds? A lot of questions in there.
Well, no, I'm just trying to figure out how to formulate an answer that's helpful. The First Amendment was designed in the 1700s, okay? We barely had newspapers, much less social media. And yes, comments made on social media are protected by the First Amendment unless they are true threats or pornographic or slanderous or libelous, all right, defamatory. Those are basically the three exceptions to First Amendment protection. On the other hand, I'd be foolish not to acknowledge that they're very disruptive. And it's troubling that this is going on by primarily students, although I understand faculty engage in this kind of behavior as well sometimes, and other employees. And there's just a cacophony of vituperative language that is disturbing. I know of situations, for example, where comments by one roommate against another roommate have been posted on Facebook or other social media outlets, and it's led to World War III between the two roommates, and the student affairs people have to come in and straighten it out. There seems to be some kind of affinity for immature people to proclaim whatever they want to say on social media, and whether they intend to hurt people or not, it definitely does. No, I don't think the institution has an obligation to punish individuals who engage in this behavior unless it is these true threats or there's some action that happens that violates the school's anti-discrimination policy, for example. But the whole the line between non-discrimination and free speech is not a clear line. There are some legal scholars who say that the anti-discrimination laws are particularly those prohibiting oral or written harassment are a violation of the First Amendment. I don't happen to agree with that, but some legal scholars do feel that way, and I don't think it's at all clear what the right answer is. So to try to answer your unanswerable question, no, I don't think that trying to intervene is an obligation of the college or university. I think that about the only way to deal with it is through education, to talk with groups of students about how these actions on social media make people feel and what their motivations might be and how they might constructively interact with people in a mature way. But beyond that, I don't think there's a whole lot we can do.
So it's not related to social media, but I've heard you talk about that every attempt at implementing a speech code at a public institution has been struck down.
Right.
So why is this the case? And you've alluded some methods, but what are some other ways that we can promote respectful discourse and hold people accountable?
Yeah, speech codes. Speech codes are rules that say anyone who harasses another individual or group or demeans them or is disrespectful on the basis of, and then there's a list of criteria, race, sex, national origin, et cetera, it would be a conduct code violation and could lead to punishment up to and including expulsion from the institution. And there have been probably a half a dozen court cases challenging these speech codes at public institutions. These are always at public institutions where the First Amendment applies. And in every single case, the court has struck the speech code, saying normally that it's vague, that it's not clear. The prohibition seems so broad that it's not clear what kind of speech would be forbidden. And so it's vague and overbroad, that the breadth of the policy sweeps in speech that is perfectly fine under the First Amendment. So this vagueness and overbreadth, the doctrines have been used to strike these speech codes. So what we are left with is conduct, that if mean speech, inappropriate speech is combined with things like defacing a residence hall room door or wall, or destroying property, or physical attacks on people, that obviously is conduct and that can be punished. Pure speech is very, very difficult to punish. That doesn't mean that you can't bring the speaker in to talk about the impact of that person's speech on others. I was quite struck once. I was talking with our Vice Chancellor for Student Affairs here in New Brunswick about complaints that she's gotten from students about comments or speech that have hurt their feelings, sometimes by other students and sometimes by faculty. And she or her team always respond to the complaints. And she said most of the time when they talk to the person who's the offender, they apologize and they feel very bad that their offhanded comment or their careless remark had the effect that it did on the other person, because they just didn't understand the impact. So I do think that education, if you want to call it with a small e, intervention, attempting to reason with people, frankly, it's the best weapon we've got.
Okay. So we know that many students at college will choose to consume alcohol. In this post-local parentis age, how much liability does a university bear, at least according to the courts, for the actions of students who drink?
Boy, you saved all your tough questions for the last 10 minutes, Tim. It's a mixed bag. It really is. If the school knows that these students are engaging in underage drinking and has undertaken to regulate it and doesn't, then there may be a problem. There was a case here in New Jersey that actually we talked about in class where the security people were accused of negligence because they didn't monitor the residence hall rooms for drinking and parties and that sort of thing. And if they had, it would have been obvious that there was a lot of underage drinking and a lot of intoxication, and the person who died might not have died. On the other hand, many courts feel that particularly if it's off campus, which a lot of this is, it's in private apartments or in fraternity or sorority houses that are off campus, that's a student choice. I don't know why our legislators thought, well, I do know why they thought age 18 was adult, because it was in the days when people were fighting in Vietnam, and the approach was if they're old enough to be in the military, they're old enough to be, they're legally adults. But there's a gap between the legal adulthood, obviously, and age 21. And that's not only the frontal lobe of your brain that's the problem. It's other things too. So there's less institutional liability actually than one might think. That doesn't mean that they shouldn't try to discourage it. Education, again, is very important. But short of placing a staff member in every student's off-campus apartment, which is impossible, I don't think, practically speaking, it's going to be able to be monitored the way that it would need to be in order to cut this way down. And if it appears to be the student's own choice, then I don't believe the institution is going to face liability.
So just a follow-up to that, the National Institute of Alcohol Abuse and Alcoholism released a great matrix this past September, and I looked through the report and I saw that you were actually on the working group for this report. And this report rated the effectiveness, cost, barriers for this broad range of alcohol intervention strategies. And I'll see if I can get someone to tweet out the link to this. So according to the report, educational programs that are featured at lots of universities seem to have little impact. And enforcing the 21-year drinking age has a higher effectiveness rate, but also comes with this increase in costs and organizational barriers. So how much time and resource can an institution be expected to invest in order to prevent students from these unsafe drinking habits?
Well, it sounds as though to do an effective job, you'd have to just stop doing everything else and do that. I mean, we all have limited resources. We have, so are you going to stop giving mental health services so that you can battle underage drinking? I mean, it's a difficult choice to make, and I think these folks are right. Students tend to ignore education that tells them things they don't want to hear. So I'm not sure what will work. Some college presidents are advocating reducing the drinking age to 18. They think that would help. I don't know if it would or not, and obviously we don't really have any data, I don't think, unless perhaps from Europe or places where the drinking age is lower. Some countries don't even have a drinking age. I remember a visit to a European country where my then college freshman son wanted to have a drink, and I asked them if he was legal, and they looked at me like I was crazy and said, we don't have a drinking age. So he had a glass of wine. He was perfectly delighted. But I don't think we have the information we need to know what's effective. Obviously what we're doing now is not working.
Gotcha. So we are nearing the end of our time here, and you alluded to some resources earlier in the show. Do you have any other books, websites, conferences, newsletters, associations that you might share that will help people continue to learn about and explore some of the topics that we covered during today's show?
Well, I think I mentioned the ones that I use, the Chronicle of Higher Education and Inside Higher Ed. The College Attorneys Association has a very good website. Some of their resources are only for members, but others are not. So there are some resources that can be used. Much as I just malign social media, the web is a very good source of information on any particular topic that you might want. Catholic University actually has a good website out of their general counsel's office that has all sorts of resources on it that are very useful. And then, of course, Jossie Bass publishes a series of books on legal issues. Ours is one, but they have others that are designed for administrators. So Johns Hopkins Press also publishes higher education related books, some of which have legal topics involved. So there's a lot of stuff out there.
Great. Barbara, thank you so much for sharing your time and knowledge today on the show. I've certainly learned a lot, and certainly lots more to think about as a field, as an industry, and I appreciate you taking the time out of your really busy schedule to share with us your wisdom today.
My pleasure, Tony.
So Heather and I will be back Heather will be back next week talking about the new book that I mentioned earlier, College in Crosshairs, Administrator's Perspective on Preventing Gun Violence, with book's editors, West Virginia State University President Brian Hemphill, and the University of Mississippi's Vice Chancellor for Student Affairs, Dr. Brandy Hefner-LeBanc, together with Kevin Kruger of NASPA and Cindy Love from ACPA. And I'll be back on February 10th, and I'm excited to have join me Jennifer Coit, the Executive Director of the National Resource Center for the First Year Experience and Students in Transition, to talk about the latest research and trends in that area. You can receive reminders about this and other great shows by subscribing to the Higher Ed Live newsletter. You can also browse the archives at higheredlive.com or subscribe to our iTunes podcast. I'm Tony Doody. Thanks for watching, everyone. I hope you make it a great week, and I look forward to seeing you soon.